Two major legal challenges that were aimed directly at dismantling key parts of the National Firearms Act have just been denied by the United States Supreme Court, and while many gun owners expected this outcome, I warn you not to treat this as just another frustrating headline that fades away. What happened here is far more serious, far more strategic, and far more revealing than most coverage is letting on, because in cases like this, what the Supreme Court chooses not to say can be just as important as what it openly declares. The court declined to hear two separate cases that challenged the National Firearms Act's restrictions on short-barreled rifles. There was no oral argument, no written opinion, and no explanation from the justices. Just a denial. That silence has angered and discouraged many people who are hoping for a decisive blow against the NFA, but I warn gun owners right now that silence does not equal endorsement. A denial of certiorari is not a ruling on constitutionality, and it is not a statement that the lower courts got it right. Both cases came from criminal prosecutions under federal law. One originated in the Seventh Circuit Court of Appeals, where a defendant was convicted under the National Firearms Act for possessing an unregistered short-barreled rifle, specifically an AR-15 with a barrel under the federally mandated 16 inches. The second case came out of Florida and involved similar facts. In both cases, the defendants challenged their convictions on Second Amendment grounds, arguing that after the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, the NFA's registration and restriction scheme could no longer survive constitutional scrutiny. Those arguments were rejected by the lower courts, and the Supreme Court declined to review those rulings. This is where I warn gun owners to slow down and separate emotion from legal reality. The Supreme Court did not say the NFA is constitutional. It did not say the Second Amendment does not protect short-barreled rifles. It did not say Bruin was wrong. All it said, procedurally, was that it chose not to take these cases at this time. The lower courts relied heavily on United States v. Miller, a Supreme Court decision from 1939, to justify upholding the NFA. Their reasoning was blunt and narrow. They claimed that until the Supreme Court explicitly overrules Miller, they are bound to treat it as controlling precedent. That allowed them to avoid engaging with Bruin in any meaningful way and instead fall back on nearly century-old case law that predates modern firearms, modern gun ownership patterns, and modern Second Amendment interpretation. Under this framework, the courts argued that short-barreled rifles are dangerous and unusual weapons. They claim these firearms are easier to conceal than standard rifles, more powerful than handguns, and therefore allegedly more attractive to criminals. Based on that reasoning, they concluded that such firearms are not protected in the same way as commonly owned handguns. I warn gun owners to recognize how familiar this logic is because it is the same justification courts have used again and again to uphold restrictions, regardless of how disconnected those claims are from real-world firearm use. The courts also repeated the argument that the National Firearms Act is not a ban, but merely a tax and registration scheme. According to this view, the NFA does not prohibit ownership outright. It simply requires registration, payment of a tax, and government approval. On paper, that may sound administrative. In practice, I warn gun owners that this framing is deeply misleading. When failure to comply with a registration requirement results in felony charges, years in prison, and permanent loss of rights, that is not a minor condition. That is a severe burden placed on the exercise of a constitutional right. Another critical part of the lower court's reasoning involved history. Under the Bruin framework, the government bears the burden of showing that modern gun regulations are consistent with the nation's historical tradition of firearm regulation. To meet that burden, the courts accepted a range of historical examples, including colonial-era barrel length requirements, militia equipment standards, early firearm taxes, and going armed laws. Whether these examples are truly comparable to the modern NFA is highly debatable, but for now, the courts deemed them similar enough to uphold the law. This brings us to the most misunderstood part of this entire situation, and this is where my warning becomes especially important. Many people believe that because the Supreme Court denied these cases, it must agree with the lower courts. That assumption is wrong. The Supreme Court denies the vast majority of petitions it receives every year, often for reasons that have nothing to do with the merits of the underlying arguments. A denial of certiorari sets no precedent. It does not affirm the lower court's reasoning. It does not validate the constitutionality of the law being challenged. It simply means the court declined to hear that particular case. There are many reasons why the court might do that, including strategic considerations about timing, case posture, or the desire to let legal issues continue to develop in the lower courts. One of the biggest weaknesses in these NFA challenges was that they arose from criminal convictions. Historically, the Supreme Court is reluctant to take major constitutional cases brought by criminal defendants, especially when those cases allow the government to frame the issue as criminal misconduct rather than a direct challenge to the law itself. I warn gun owners that courts are far more comfortable sidestepping constitutional questions when the plaintiff is already convicted of a crime. These cases also allowed the government to portray the issue as one of tax evasion and failure to register, rather than as a fundamental challenge to the National Firearms Act as a whole. That framing matters. It gives courts an excuse to avoid confronting the deeper constitutional problems and instead focus on procedural compliance. From a strategic standpoint, these cases were not ideal vehicles for dismantling the NFA, and the Supreme Court knows that. What comes next is where gun owners need to pay close attention. Stronger, cleaner cases are already moving through the courts, and they are structured very differently. Many of them are civil cases rather than criminal prosecutions. They challenge the NFA on its face, rather than as applied in a criminal context. They focus on registration as a prior restraint on a constitutional right, especially now that the NFA's tax component has effectively been reduced to zero, weakening the government's justification for treating it as a revenue measure. There is also a growing body of evidence that undermines the dangerous and unusual argument. Millions of suppressors are legally owned by civilians in the United States today. When combined with short-barreled rifles and short-barreled shotguns, the number of NFA-regulated firearms in lawful civilian use reaches well into the millions. The Supreme Court has previously recognized far smaller numbers as sufficient to establish common use, and that reality continues to erode the foundation of the government's position. I warn gun owners not to underestimate the importance of this shift. When the National Firearms Act was passed in 1934, the landscape of firearm ownership looked very different. Today, lawful ownership of NFA items is widespread, well-documented, and overwhelmingly associated with responsible, law-abiding citizens. That fact makes it increasingly difficult for courts to justify treating these arms as rare, exotic, or outside the scope of Second Amendment protection. At the same time, lower courts are struggling to reconcile Bruin with older precedent. Some are openly resisting it. Others are attempting to narrow it. Several Supreme Court justices have already expressed frustration with lower courts that refuse to apply Bruin faithfully. That tension is growing, and it makes future Supreme Court intervention more likely, not less. I want to be honest and realistic with gun owners. The National Firearms Act is still in effect. Registration requirements are still enforced. Federal courts are still relying on Miller and similar precedent to uphold those requirements. Compliance is still mandatory, and the consequences for noncompliance remain severe. This denial did not change that reality overnight, but it also did not close the door. Major Second Amendment victories like Heller, McDonald, and Bruin did not happen quickly. They were the result of years of litigation, careful case selection, and persistent pressure. Those decisions came after many losses, many denials, and many moments that felt just as frustrating as this one. So here is my warning to gun owners. Do not mistake delay for defeat. The Supreme Court did not bless the National Firearms Act. It did not reaffirm Miller. It did not rule against Bruin. It simply chose not to engage yet. The real question is not whether the NFA will face a serious constitutional reckoning, but when that reckoning will come and which case will finally force the court to confront it directly. The NFA is increasingly out of step with modern constitutional doctrine, modern firearm ownership, and the plain text of the Second Amendment. Pressure is building, cracks are forming, and the legal landscape is shifting. This story is far from over, and understanding what comes next is more important now than ever.